So welcome to the first 2020 webinar series in the Syracuse Intellectual Property Law Institute. This is Professor Shubha Ghosh at Syracuse University College of Law. And I'm very happy to welcome Professor Lucas Osborn from Campbell University School of Law. Professor Osborn, Lucas, welcome.
Thank you very much. Thanks so much for having me.
Yeah, good. It's great having you, and you're launching the series for the new decade too. So it's great and how timely. We're going to talk about 3D printing in your book. It's about a year old now. Is that right?
Let's see. Yeah, hard to believe.
Yeah, it's amazing. So 3D printing and intellectual property, published by Cambridge University Press last year, and I read it when it came out of the press. Read reviews of it, and you're kind enough to send me a copy, and it's great to launch the series with you. So, want to launch us off? Tell us a little bit about the work you're doing and a little bit about the book.
Sure. So a little background on me. My main area of research is patent law and intellectual property. Practiced for a few years before joining the academy. Was an engineering major, like many people who go into patent law, and had written on some other topics. And then in about 2013, became aware of 3D printing technology as it sort of hit the mainstream around that time. And one of the great things about being an academic, of course, is you can pursue your interests. So I married this sort of technological interest with the legal background and started what originally I thought would just be one article on exploring 3D printing and intellectual property, and it turned into half a dozen articles and then the book. So it's quite a journey and sort of unexpected in a lot of ways, but it was fun.
Yeah, no, that's wonderful. And what's your background in engineering, Lucas?
I'm a chemical engineer by training. So.
And how is that getting into the technology of 3D printing? It's an interesting switch. That's what's great about this field, right? And also being an academic, you get to explore all sorts of different areas.
Yeah, it is. And there's plenty of material science, which is sort of a chemical engineering discipline that goes into the sort of the ink, if you will, that you 3D print with, the materials that you can 3D print with. So.
Yes, that's a great segue. Tell us a little bit about the technology. I know the book talks a lot about the digital technology and the computer science, and that's going to be something we'll talk about in a few minutes. But tell us a little bit more about the technology, because there's a lot to 3D printing, right?
Right. There's the hardware, and then there's the software, and then there's the materials that you print with. And the hardware, there's a variety of ways to 3D print. And if there's people that are listening that have not come across 3D printing, the idea here is instead of injection molding or instead of scraping away material, 3D printing builds an object up layer by layer from the ground, much like you would build a brick wall, and sort of the first layer, then the next layer. And so you have, in some of the simplest versions, a nozzle that traces a pattern for one layer, and then that nozzle moves up a fraction of a millimeter and drops down the next layer. And most home-based 3D printers use plastic, some sort of melted plastic, but you can 3D print in a variety of materials. So it's, the plastics, there's a variety of metals that you can print in, which is very valuable, obviously, for a lot of finished industrial products that are being printed. You can print in anything you can sort of grind down to a powder or pelletize or something. So in wood-based materials, ceramic-based materials. And then, of course, the exciting stuff is some of the bioprinting. So printing in human cells or animal cells that are in some sort of hydrogel. 3D printed food, so you can get all sorts of different shapes with chocolate or other things. So that's the materials, that's the hardware. And then, of course, the software is what drives the whole engine. And all three of those areas, the hardware, the software, and the materials, are all continuing to undergo rapid change and development. And so it's a nice virtuous cycle. As all three of these things advance, 3D printing sort of reaches more and more of our daily lives.
Yeah, no, it's really interesting. We think about the way in which digital technologies and printing technologies have affected intellectual property and our lives. We take 2D printing for granted, I guess we'll call it that. But as you say, the cost of typical laser printers went down, I think, in the 1990s or so. You can get a good cheap one, and now most homes have more than one. I know we have several in our house, and they drive me crazy sometimes. But,
yeah.
Are there home uses of 3D printing now? They're
Yeah,
still fairly expensive, right? The printers.
so the basic patents on some of the thermoplastics that are the least expensive to build and use, some of those basic patents expired in the late 2000s or early 2000, zeros. It's about 2009 to 2012 in there. And so at that point, you started seeing home-based printers for under $1,000.
Mm-hmm.
Now you can get a home-based printer for under $500. And if you're willing to sort of build it yourself and tinker, you're looking at a couple $100 if you're willing to assemble it yourself. So it's very accessible to many homes, but those printers are somewhat limited because they're printing in plastic. You certainly can't go home and print yourself an iPhone or something like that, but there's a lot of creative uses that people are putting them to, and a lot of children, in junior high or high school are doing projects on 3D printers and doing amazing things. There's a worldwide network, for example, of people who are doing open source prosthetics. And so some people will upload the design files for a prosthetic device, and then these people can shape them for a friend or a family member or what have you, especially for children who are growing and need to adapt and grow. Their prosthetic devices need to grow with them. So quite a variety of uses, even within sort of the less expensive home-based printers.
Oh, interesting. And so I'm sure there's like sort of a, for lack of a better term, kind of like a community, hacker community or 3D community. There must be interesting listservs and other Facebook pages and social media that discuss this. It's
yeah, you've heard of these maker spaces and maker labs. And 3D printing is a big part of that. That's not the only part of those maker spaces. Yeah. And in most colleges now, I mean, it's routine to have many 3D printers on any college campus for engineering students. And
see them around here. It's interesting. Pop culture. I think the first time I saw it in pop culture was in Ocean. I think the movie Ocean's 8, 3D printing. I don't know if you have seen that. It was a big part of that movie in a kind of funny way. So no, it's definitely going to be something that we'll see around us. How about products, sort of industrial products or other things you might see in the mall or buy off the net? I mean, what kind of things are being used to produce? What things are being produced with 3D printing?
So it runs the gamut. You know, early 3D printing was used. Let me back up. 3D printing was invented in a sense in the late 1980s, and they call it additive manufacturing, adding layer by layer. Mm-hmm. But for most of its early time, it was used to simply make prototypes. So there's an acronym or a nickname is sometimes rapid prototyping, because they were printing in sort of plastics and other materials that were not good for end use. But now that you can 3D print in metals very effectively, you have companies like GE taking a very big investment in 3D printing.
Yeah.
You're looking for right now where 3D printing is either low volume production relatively. So GE is manufacturing jet engines and rocket engine equipment, and those are going to be relatively low volume compared to automobiles, for example, or high geometric complexity. Those are two things that high geometric complexity is something 3D printing does very well, because to the 3D printing nozzle, it doesn't matter if I have to print a curve or a straight line or what have you. I don't have to remove the material. And so at these lower volumes, it's very cost competitive or better than other mass production techniques. And then as you increase the geometric complexity, 3D printing is very advantageous. So you see things like fuel injection parts, nozzles, and in ways that you can take multi-component pieces and take them and 3D print them in one piece, so you don't have to assemble multiple pieces. So those are some of the things that 3D printing does very well.
Interesting. I'm sure the uses will just expand as the costs go down and the patents and IP.
Nike sells a 3D printed shoe. Mm-hmm. Like I said, you can 3D printed food, and so some restaurants are doing that for some of the interesting designs that they can come up with. And then the bioprinting, like I said, was in the early 2000s that they 3D printed a bladder, a human bladder, and implanted that in a human being who still has a working bladder. So.
That's really interesting. Of course, those aren't cost effective yet, right? But they're more
Well, it depends on,
Yeah.
right. It depends on
Yeah.
the need. What they want to be able to do is 3D print more complex tissues.
Yeah.
But bladder is very thin. But as you get to more complex tissues, what's the biggest roadblock, or one of the biggest roadblocks, is the vascular, getting the blood vessels to flow into these organs. That they can print the cells, they can print the shape, but they can't get the vascular system
Yeah.
to.
Interesting.
Yeah.
Well, I mean, that suggests all these FDA issues. I don't want to go off on the tangents there, but those are really another real area. Is it a medical device? What exactly, should there be a new, so it's not really a biologic, but it certainly is in that kind of realm. It's really interesting.
Yeah.
So those areas, those are regulatory areas. Let's talk a little bit about the intellectual property, Dan. I mean, you mentioned the hardware, you mentioned the software, you mentioned these new products that are being created, like the bladder, which also could be subject potentially to new types of intellectual property protection. Do you want to give us a sense of the intellectual property landscape that 3D printing has exploded?
Sure. That's the subject of the book, and that
Right.
this is as wide as intellectual property is itself. I think what I tried to do in the book, though, is figure out what are the new or difficult issues. So let me give you an example that I thought of something I think is not difficult, which is if I come up with some invention, a new whatever shovel or mousetrap, it doesn't matter whether I 3D print it or whether I manufacture it using traditional methods. That physical mousetrap is going to be judged the same whether it's 3D printed or not. So
Right.
that's not necessarily a new issue. Where most of the new and exciting issues come with intellectual property is the fact that you have a digital version of what then becomes the tangible object. And we kind of skipped over this when we talked about the technology. I mentioned the software, but to understand the IP implications, I think it's very helpful to understand the process by which you create a digital file,
Mm-hmm.
which can be in a CAD program, drawing on your computer,
Computer assisted design, yeah.
Yeah, or you could do it by scanning an existing physical object. They have these 3D scanners now, and
Mm-hmm.
we can take very high resolution scans and create a digital version. So, yeah, what I call physitization is this idea of going back and forth between the physical and the digital worlds.
Mm-hmm.
A digital file is what contains the instructions to print the tangible object. And so the easy analogy is we had records and CDs, and then all of a sudden we had MP3s, and that caused great disruption for the copyright world, for music, because we had these MP3s that could be shared around the internet, and then people could play them on their computers and their iPods and that sort of thing. And you're starting to see the exact same thing with now what are physical objects like machines, widgets, shoes, other things like that are now digitized.
Right.
I can take that digital file, share it around the internet, send it to people, or I can 3D print in relative anonymity, because I can print that in my garage or somewhere else where it's going to be very difficult for somebody who holds intellectual property on the tangible object. How are they going to detect and catch me doing this? So those are some of the big picture disruptions.
Yeah. So let's talk about that. There's that's so much. I mean, one of the things I like to, when I first getting into an IP topic, thinking about ownership and then thinking about infringement. But here, those lines kind of blur pretty quickly. So let's kind of talk about how they interface. I mean, one of the things with digital copyright, when that hit the policy and legal landscape in the 1990s, one of the mantras was that copyright is dead. I mean, I think even now I sometimes hear some of our colleagues talk about that. I think one of our colleagues has that as a sign off on their email. But so is IP dead now? I mean, or is patent dead at least, or trademark dead? I think that just to kind of put some flesh on why people were saying copyright is dead is the whole idea of copyright is try to protect people from unauthorized copying. But now if copying is so easy to do and so prolific, copyright becomes kind of almost a lost cause. It's there and keeps people busy, I guess, sort of. But it's really, I guess the argument is that copyright is dead because it's ineffective. So is that what's now happening, you think, with the creation of 3D? It's just an expansion of that to other areas of IP?
It would probably be provocative and maybe get more people to read a book or just to title it that. But no, I don't think so.
Okay.
If I'm trying to be objective about it, as exciting as the technology is, there's some real limitations to it. But
Okay.
so what becomes, I think, a narrower question, but an interesting one is, for the things that can be produced with 3D printing as end user parts, is IP dead for those sorts of things?
And IP dead in the sense of being less effective, yeah.
Less effective or less necessary to
Yeah.
spur innovation. And I think that's an open question. It's not one that is front and center enough for, I think, the country to really squarely address it. But for certain industries, for certain component manufacturers, their world has already been severely disrupted. And so they're asking those kinds of questions, and governments across the world are asking those kinds of questions. How does patent law, how does copyright law need to adjust based on 3D printing? And thankfully, I think right now they're taking a slow approach, a methodical approach, and I think that's a good thing. If I have one big theme in how I would approach regulation, it would be go slowly. Don't do anything drastic. Patent law is not dead, but and it may need to be tweaked, but we're not there yet. And the reason we can even ask this question about is patent law needed with 3D printing technology is how drastically 3D printing technology lowers the costs of the whole innovation cycle. And that's worthy of careful study. So from the time you come up with an idea to the time you get a working prototype and even a commercial saleable embodiment, it can be drastically reduced with 3D printing. As soon as either I have my own ability to create something in a CAD program, or I can use many service providers to do that for me, we're talking about a turnaround of a day or two. Opposed to waiting for the machining process and the cost of creating the machining process to see a prototype. I can do that in a day or two. I may need to iterate and tweak that prototype, but again, every turnaround is a day or two. We're talking about a few $100s as opposed to maybe thousands to tens of thousands of dollars to machine in traditional manufacturing. So we go from needing hundreds of thousands to maybe millions of dollars to really launch a product to thousands of dollars that you could crowdfund, that you might get from friends or family or investors. So it really does lower the cost of the innovation cycle. And that's what patent law is there for, is to incentivize people to take on those costs and risks. And if the costs are dramatically lowered, maybe patent law needs to be lowered along the same lines. But of course, we're talking about individualized products, and patent law is a one-size-fits-all system. So we're not there for patent law generally.
I know. I mean, we have the Technology Commercialization Law program here at Syracuse and the Innovation Law Center, and one of the entrepreneurs that came through here the last couple of years has a nice startup in New York City in the fashion industry, where they basically take digital files of fashion and make copies of it. Now, these are authorized copies. These are not. So these are I kind of view them as the proto FedEx Kinkos of the 3D printing fashion world. And of course, one of the issues they had is what do you do with these files? How do we prevent, how do we limit the exposure that FedEx Kinkos had to unauthorized, copyright infringement? That was one of the big problems in the 80s and 90s, and now different ways to deal with that. So there's that important area where you see 3D printing having an impact, and then also spare parts. The automobile spare parts. That's had a lot of discussion. It's gotten some press, but less so. But than it probably should, in terms of new legislation in the U.S. and in EU trying to deal with spare parts. And I think some of the candidates, I think Senator Warren and Senator Sanders have also talked about this right to repair issue. And that fits in with the spare parts debate. So that definitely comes in the wake of all of this development in digital technology, which first of all makes spare parts very easy to copy. For at the cost of all the patent owners in this particular area and the copyright owners in this area, but it also affects the right to repair. I mean, you mentioned this whole idea of the modifying prosthetic devices, right, which definitely fits into this right to repair issue. So all of that is sort of lots of things to discuss there, but I think it's leading up to the next question. That is, copyright didn't die; it just created a new field, which is digital copyright.
Right.
And one way to read your book is that you're kind of, whether implicitly or explicitly, laying the groundwork, I think, for a new area of maybe digital patent or digital trademark or digital design. There's so much going on in your book. Maybe the next generation of digital copyright. So how about that? How about kind of running with that for a little bit, that so much IP isn't dead or ineffective. It just opens up a whole new field that you're kind of launching.
Yeah, and I think that's a good way of putting it. And I didn't frame it that way necessarily in the book, but I think that's a good possibility for exploring. Okay, maybe we don't need to change patent law wholesale, just like we didn't need to change copyright wholesale, but maybe we should take notice that things really change when we enter a digital environment. Costs, risks, other things really start to change. The cost of copying as well. You know, I've been sitting here talking about the cost of innovation has decreased. Cost of copying obviously goes down to virtually zero.
Yeah.
And so that really upends a lot of assumptions in patent law, just like it did in copyright law. And so it's very useful, I think, to say, okay, maybe we address digital patent law as its own subset. And really, you could roll software into that. I mean, software is a poor fit for patent law in so many ways. And of course, with Alice now, I mean, it's a mess with Alice versus CLS Bank and the patentable subject matter doctrine. So that kind of issue could go beyond 3D printing, and it might be a good way to say, okay, maybe patent law should not be one size fits all. Maybe we can bifurcate out the digital stuff from the tangible and the industrial.
Yeah, and I think your book does a good job in thinking about that. It's a whole chapter, in fact, talking about digital infringement and some of your work with Professor Holbrook at Emory and some of the work you've done in terms of expanding on those ideas. You want to talk a little bit about what that digital patent law might look like?
Yeah, so that's something that Tim Holbrook and I, Tim at Emory, of course, worked on as one of our co-authored articles. And the idea was, okay, patent law, if you have a patent claim, and for those that aren't big patent law people out there, patent law is rather technical and it's somewhat literal. So if I have a claim to a tangible device, let's say I invented a new shovel or something simple, I invented it, it's new, nobody's ever done it before, and it's not obvious, and I get a claim to that shovel, that claim only protects the physical shovel. It does not protect the digital version that can 3D print that shovel. And that leaves a gap of protection for people. And for various reasons, it's not as easy to simply say, well, draft a claim to the digital version of the shovel, because it turns out the 3D printing progression is that the only digital file you could arguably patent is not the digital version that people buy and sell and trade on the internet. And that gets in a little bit of the technicalities, and if we have time, we can talk about that. But bottom line, it's difficult to get effective digital coverage. And so what Tim and I said was, well, maybe we can look at patent law, and we're trying to find a way to do this as doctrinally possible, as much as doctrinally possible, I should say. And so we took a lead from a case called Transocean versus Maris. It had nothing to do with 3D printing, but in that case, patent infringement was based solely on an offer to sell an item that had not yet been built. And so the idea was, that's a type of intangibility like digital versions are. Yeah. And you could extend this to the sale or the offer for sale of digital files, because that really is a sale and offer to sale implicitly of what will be digitally manufactured. And so we said, based on that case, we could make a small extension and find digital patent infringement. When you sell the digital file, even though you're not selling the tangible object, you're disrupting the economic incentives. That's what, by selling or offering to sell, that's what patent law is seeking to sort of manage. Yeah. Find infringement there. And then sort of interestingly, we said, well, should we make things like making the digital file or just using it on your computer, should we make that infringement? And there's arguments both ways, but we ultimately said, no, let's not make that infringement, because that making on my computer or using it on my computer and not actually physically manufacturing it, that doesn't disrupt that much of the economic model that patent law is based upon. And instead, that activity speaks to playing with the technology, trying to invent around the technology, trying to build upon the technology. And those are activities we want to foster to some extent while still giving patent rights in the thing that was invented. So that was kind of the bifurcation we came to.
There's a lot there to unpack. I think it's good to try to unpack because so one is the question of what exactly, are digital files patentable in and of themselves? Is that another part of what the dimension of the invention will be? And then the infringement. And let's go back to take apart the infringement issue because it's pretty interesting. We can go back and circle back to the question of patentable subject matter and patentability more broadly. So about the infringement. So the issue, just to clarify, so we're all on the same page. The underlying patent is for whatever the product or the process or composition of matter or machine is. That's not really changing. We'll assume that's patentable. The question then is whether making a kind of a digital version of that, a 3D scan or whatever the digital file looks like, the DMF, the digital manufacturing file, or the other types of files you talk about, of the product, machine, or composition of matter. I guess that's kind of an interesting question about doing a DMF of a process. I guess that's possible. I have to think about that, but you're asking whether that's infringement. That's the question, right? So,
right.
And as I understand your approach, just clarify if I get it wrong. You're saying that the basis for it would probably not be in the using or making necessarily, but in the selling or offering to sell. So in other words, I'm making that 3D scan or the 3D file, whatever we're going to call it, the DMF. That would be a potential offer or sale when I try to sell that file or distribute the file. Is that right?
Yeah, the sale and offer to sale on the one hand, because there you're appropriating the economic value of the invention. In the vast majority of the cases, if I'm selling a file to you, you're going to print it. You want the file to just look at it. You want the file to print it. And so you're taking the economic value there.
Yeah, okay. And that's interesting. Let's take that apart. That raises lots of questions about exhaustion and questions about whether, IP should protect economic value or protect something else. What does that mean? Let's just go back to something basic. I think I understand the argument why you don't want to put it under making. It doesn't seem like you're making the actual product or in the way we think about it. But aren't you using it? I mean, so we do think about intermediate copying as potentially actionable under copyright law, and we can think about intermediate uses in patent law in the same way. And the notion of use in patent law strikes me as fairly broad. So wouldn't just the scan be a use that's potentially infringing?
You could certainly go there. You could certainly go there even with making as well and say, well, you've made a digital version. Why else are you making it except to eventually manufacture it? I think it's for some ways, for me, easier to say, I'm not too worried about the using it because there's two ways one could use a digital file, at least two ways. One is I can use it within the computer environment. I can look at it, I can manipulate it, I can run diagnostic tests with software.
The
other way I can use it, obviously, is to print it. Well, once I've printed it, I've made the physical embodiment, and I'm a direct infringer then. So sort of the using in terms of 3D printing it, you're going to capture that individual by the tangible embodiment that they've printed. So really we're only talking about the using it in the digital environment, and that strikes me as the kind of inquiry and testing that we might want to encourage. If they don't take that step to then manufacture.
Yeah, we could take apart the making issue as to making the actual final product or the machine versus the 3D version of whether that's a different type of making. But I think we're kind of talking about the same thing when you're talking about it in the context of the use in a digital environment. So putting it in traditional kind of doctrinal terms, it sounds like you might be describing what we think about as sort of experimental use and in patent law, maybe that it falls into those types of defenses, or this kind of catch-all that kind of gets people's maw sometimes, implied license, that somehow within the digital environment, that environment has changed. And so the kind of things that are implied licenses of the patented work have also changed. And now that includes making these or using the patented item to make these 3D files, the DMFs. Is that kind of the vision you had in mind for use or make? Or
Yes, I think the policy would be along the lines of experimental use for sure. Now, of course,
yeah,
experimental use in the United States patent law is very narrow.
yeah, right, that's next.
So we'd have to rethink that a little bit to include these kind of uses and makings as quote experimental use. But I think it fits with the policy of what experimental use is about, as long as that's not going to take the legs from under the patent right itself, which is where when you either sell or offer to sell, or you create the tangible embodiment, that's where you have crossed the line, and now you're taking the value of the patent.
Yeah, so about the sell or offer to sell, so you wouldn't think that would be covered by exhaustion. I mean, I'll ask that that's kind of a leading question because I kind of know what your answer is going to be, but maybe I don't actually. I'm being presumptuous. I mean,
I think it depends on who does the selling or the offering of selling.
Okay.
So if you're buying an authorized file, yes.
Let's say I bought the authorized patented invention, made a 3D file out of it.
Right. And then if you're buying
it,
certainly an implied license to print it, you would have a exhausted right to print that file one time, I think. Maybe not multiple times.
But I couldn't resell it. That wouldn't fall under exhaustion because I'm not selling the actual, I'm selling a copy of the copy, not the...
Right. And so you're right, exhaustion isn't a perfect fit there.
Yeah.
But I'm thinking more about the infringer who creates the file.
We're going to get to them next. Yeah, I'm just trying to get, Well, that's what's interesting because there are all these interesting cases. I mean, this came up in the, this is coming up with ebooks. I mean, there are all sorts of questions in the copyright area regarding digital exhaustion. You've got multiple decisions in the EU and the copyright area about digital exhaustion. Yeah. And you got the Bowman case. The Bowman case, I thought, is kind of this underrated case from the U.S. Supreme Court. I mean, the court really ducked this digital exhaustion issue, and they made it clear. I mean, the Federal Circuit had a very broad holding, I thought, that's the one about the reuse of the seeds, the replanting of the genetically modified seeds in violation of Monsanto's patent by the farmer in Indiana. And the Federal Circuit's decision was talking about if we applied exhaustion here, it would eviscerate patent law left and right and so forth. And so they're very wary about it. And they're clearly thinking about digital exhaustion. They may not have been thinking about 3D printing, but certainly it was on the horizon back there. Right. And then the U.S. Supreme Court had kind of a narrower holding. I mean, I think they made it clear that the making, doesn't fall under exhaustion. This is why I asked this question about exhaustion, though they said selling does, and so this is kind of this hybrid area where you're making and then selling, and they probably wouldn't push exhaustion that far, but they did also leave open as to we're not going to go on into the digital area, but they certainly suggested that's on the horizon. So this is just another area where I think your work is very very important in terms of that intersection.
And it strikes me that IP can have a good default rule that can then be contracted around as parties see fit. And that's the way perhaps to maintain, again, assuming we need it, we probably need a default rule that protects the value of the invention if we need that incentive there. And then we can contract around it. And I can say, actually, you could print this file 5 times or 10 times, but that's something we negotiate.
Have you looked at the contracts surrounding these DMFs and the 3D printing? I mean, how are they? I'm sure there are lots of waivers of liability and limitations on use that are in those contracts, both for the 3D printer and then for anything else that involves the dissemination of the DMF files or the other files.
Yes, I've had some companies reach out and done some consulting in answering those very questions, and there's a lot of concern. And the good thing for those companies and those lawyers is, based on other digital files and technology that you've worked with, not necessarily 3D printing, the same issues are occurring the same way here. You've got to have some sort of technological policing and protection mechanism. Once I give the file to you,
you're talking about outside of contracts, sort of. Okay.
Right, outside of contract, you definitely have your contracts, but you probably want the belt and suspenders of some sort of technological protection.
Right, good.
And that's what people are seeking technologically, is maybe I can just, beam the file to your printer one time and you don't get to keep it. Of course, you can surreptitiously copy that
Right, which
data
would
that
be
you do you
problematic,
want
to
to
say the
supposed
least.
to, and that sort
Yeah,
of thing.
yeah.
Right.
Well, no, this is interesting because this gets back to our discussion about digital copyright a few minutes ago, right? Because you did have, as you said, a whole new area. It's not that copyright died; it just proliferated in some way. And
Right.
digital copyright and the Digital Millennium Copyright Act. And I think you and others maybe have talked about a Digital Millennium Patent Act, maybe
Yes.
on the horizon, or some other sort of technological protection measures that come up in this area. I think they already exist in patent law because books of trade secrets. I mean, even though you might have a patent on an invention, there's still lots of trade secrets that are associated with them. Do
Right.
you want to elaborate on that a little bit? You talked about that, but do you see what would it be? I'll do the math. The DMPA. Do you see a
MPA,
DMPA
right.
coming up in the horizon? Or
Yeah, I think there's two areas that call for something like a DMPA or some sort of doctrinal change. One is the real problem, I guess you could say, of innocent, and by that I mean completely unintentional, individual infringers. And individuals, I mean individual people. Certainly, innocent infringement is not a general defense. So if a company or even an individual right now under patent laws makes use, sells, or offers to sell something that's patented, they're an infringer whether they were intentional or not. But this could become a significant problem for individuals who realistically, you've read patents, I've read patents.
yeah,
The average layperson has zero chance of reading a patent and really appreciating what the contours of that legal right are.
yeah, yeah,
And that's very different, I think, than copyright law. People knew if a song was copyrighted in general. They may have said, I don't think it's wrong. But once you know that copyright exists, you basically know any song I want to copy, if it's worth copying, it's copyrighted, and same with books.
right, right,
Whereas patent law, it's you can't tell if something's patented or not unless you read it
exactly,
closely,
yeah,
and then there's a lot of uncertainty. So you have small companies and individuals who may innocently infringe.
yeah,
And the other area is sort of these third-party service providers who would be like the Kinkos and the FedEx printers, where you go to, I can't afford a metal 3D printer, but I can certainly have a third-party service provider print my file for me. Well, now that third-party service provider is making a tangible embodiment, so they're going to be a patent infringer if
right.
the tangible object is covered by a patent. And they also have no chance of in any cost-effective way policing whether something's covered by a patent. It's just,
It's
a patent infringement opinion is a $10,000+
yeah.
Per opinion job. So
Have we seen? Let's talk a little bit. We didn't talk. We kind of brushed over, but it would be worth. I think it's probably the right place to dive into a little bit deeper. Have we seen a proliferation of lawsuits in the 3D printing patent space or IP space? Or we certainly saw a lot of digital litigation in the the 1990s and the 1980s even. Yeah.
Yeah, you haven't seen it in the patent space. There
Yeah.
are stories that are very that I have read that there's clearly some patent rights that probably were infringed, but because they were individuals, because it was relatively harmless, they weren't making a business out of it. Probably nobody cared. The most famous, I think, is there was a design student who learned how to use 3D printing. He actually printed his own non-brand Invisalign, but the teeth trays.
Oh,
he
interesting.
printed his own teeth, and Invisalign had a patent on the process of scanning your teeth, creating intermediate scans of where the teeth need to move, and printing these trays, these teeth trays. And this student did it, so almost certainly infringed their patent.
Yeah, yeah.
But who's going to go after it?
Yeah, I guess the technology hasn't picked up as quick. And this goes back to your point earlier, as it did with digital technologies, where
and I think that patent so many. There's so much fewer things that are patented.
Yeah, yeah,
we take down notes, we sing a little melody, and that's copyrighted.
Yeah.
Whereas patent is a much steeper hill to climb. So most of the infringement is probably that's worth litigating is going to be companies that are using 3D printing technology for detection or.
And I think when you looked at CD players in the 80s, I mean, they proliferated pretty quickly. They weren't, I don't remember them being all that expensive when they came out, or relatively expensive. But then, I guess this is part of digital copyright lore. Maybe I got this lore wrong, but when the CDs, the music CDs were first launched in the 1980s, I mean, they weren't even protected. I mean, they could be ripped pretty easily, and it's only later on that the music industry caught on to that, or became a matter of technological protection measures and things. So that dynamic is a lot different than what we're seeing, what we're seeing now. But I imagine, as you say, the cost of printing going down, or the printers going down, then maybe we'll see more of this. I mean, the Invisalign case is a really interesting one. Maybe it's a harbinger of things. So
Right.
yeah, one of the things we left open, and then we can move on and maybe talk about the trademark portion, because that was really interesting. But I did want to talk a little bit about this patentable subject matter issue, about whether creating these DMFs themselves are patentable, whether the files themselves are patentable. And I think you were suggesting that they don't fit into existing patentable subject matter, and I think that's right. It doesn't seem like a traditional product or a manufacturer or composition of matter or process. Do you want to elaborate on that a little bit? I mean, do you see maybe developments in patent law that would then address square on protection for patent owners over DMFs?
Yes. So everything starts with the caveat of Alice versus CLS Bank,
Right.
the upheaval. Yeah. We don't know what's patentable subject matter right now, but there are patent claims right now being issued for a digital file, a computer readable medium is the way you traditionally draft these claims. So some sort of digital media, whether a thumb drive or a CD or floppy disk,
Right.
Some computer readable media containing code that will instruct a machine to manufacture a shovel or whatever the patentable object is.
Yeah.
Those claims are being issued. The problem is they are somewhat valueless in the 3D printing world, and that gets back to there's a progression of files right now in the 3D printing process. So I start with the first kind of file, which is your traditional CAD file that people have been using for generations. That is a sort of 3D model, but it is the traditional CAD environment. I can't 3D print from that file.
Yeah.
I have to translate that file into an intermediate file format called a surface mesh file.
Yeah, right.
The surface mesh file is a tessellated object. So I take the surface of whatever object I've designed in the CAD environment, and I basically lay down triangular scales, like the scales on a snake or something, that covers the entire surface. That particular file format, the surface mesh file format, is what people, when they buy or when you go online to download 3D printable files, that's the version that you're downloading, because that's a universal format. But that format is also not 3D printable directly. It does not have the instructions for the 3D printer. So the file format with all of the economic value is a file format that you can't protect with patent law, because you can't draft a patent to a digital file that has an image in it.
Yeah,
right?
yeah.
Photograph, let's say.
Right.
And so it's only when I translate that surface mesh file into this final version, which we call a G-code or machine instruction file, that's one where the software slices it layer by layer to the slices that will be 3D printed. And that file, that machine instruction file, has the code, has the instructions to tell the machine what to do. That file format is probably patentable.
Yeah.
But that file format is specific to your 3D printer.
Yeah.
My 3D printer is going to have a different G-code or machine instruction file, even though we both started with the same surface mesh file, because it's key to the temperature, the capabilities of my printer, the materials that I'm using. So that's the protection gap in patent law, is even though you can get a computer readable medium claim, that's not what's going to be directly infringed.
So, we haven't talked about, copyright except indirectly here, but I have to go back and look at the structure of the industry, and maybe you're obviously more expert on that than I am off the top of the head. But so do a lot of the 3D printing companies, the manufacturing company, whatever that, how that business structure is like, I guess it relies still on copyright still for these codes, right? I mean, for protection for these codes.
For the software that runs the 3D printer.
Yeah, especially for the specific ones, yeah.
Yes, they certainly do. They could
Interesting.
also have patents. I mean, you never know what is
No,
allowed.
I'm sure there are patents as well. I was just, we haven't talked about copyright. When you're talking about the specificity of code, though, that immediately,
Right.
talks trade secret and copyright. We didn't even talk about trade secrets as well. Yeah,
Yes.
Interesting.
And I think that's a segue to the copyright. I think that
Yeah.
the code for the 3D printers, sure, copyrightable under current doctrine.
Yeah.
What I think is the interesting issue in copyright law is narrower than, let's say, patent law that I think is just generally disrupted. But for copyright law, as you said, it's been dealing with the digital wave now since the 90s. So it's settled a lot of those problems. So in many ways, it's ready for 3D printing. If I have a digital version of a statue, we know that statue is copyrighted. The digital version is also copyright protected and would be infringing. That is clear.
Right.
I think the interesting issue is now that we're digitizing tangible utilitarian objects in a way that we never did before, we really are starting to butt heads between copyright and patent.
Yeah, absolutely. Yeah.
How are we going to sort that out? Do we need to sort that out? With software, we've sort of said, with traditional software, we've sort of said, well, you always get a copyright, and if it's inventive enough, you get a patent.
Right.
So you can have both and protections. I'm not sure if that's the best policy for digital versions of utilitarian objects. Because I always pick a shovel, and you know why, because of Star Athletica, the copyright case that said a basic shovel is not copyrightable. We know that, says the court. Well, what if I take that non-copyrightable shovel and I have a digital version of it?
Right.
To me, my just gut reaction, first instinct is that digital version should not be copyrightable either.
We have the Meshworks case, which you talk about in the book as well, which is a great, really interesting precedent. Yeah, which is a 10th Circuit case.
Meshworks was a kind of narrow holding in some ways because they were taking the direct measurements from a physical car.
Yeah.
And I think that maybe on the facts that was a closer case than the court gave it credit for, because there was a lot of massaging on the part of the digital people. They took the data from the car and then they had to massage it a little bit.
Yeah.
But even if I create a shovel from scratch in a CAD environment, that's a different scenario. Many people agree with me. If I take a 3D scan of a shovel, that scan is not copyrightable.
Yeah.
But what if I just draw a shovel from scratch in CAD? Many copyright scholars say, well, no, that is copyrightable. And they say things like, well, look at Blystein, and anytime I paint a realistic painting of a apple or a mountain, even though I'm copying the mountain, that's still the impression of the artist.
Yeah.
And I don't know that language and that policy translates to me making a digital shovel. I don't know how much of my personality as an artist is embedded in my digital shovel that I size and shape for purely utilitarian reasons, and I can do it exactly in the software. So,
I mean, it definitely gets into all these questions about, copyright protection for AI-created works. It's not exactly that, but it's sort of the same question about where does the machine intervene.
Right. I mean, the machine is taking, to me, it's about creativity.
Yeah.
That's where I couched it and said, the kinds of choices I'm making when I'm designing a digital shovel are not copyright kinds of choices. They are all based on utilitarian choices, economic choices, those sorts of things. So it sort of constrains out the creativity, and I make the sort of provocative argument that a lot of people don't like, which is if all you've got is a digital file of a utilitarian object and nothing else, then I don't think it should be copyright protected.
Yeah, I think I would tend to agree with that. I mean, it's interesting to see it within the contours of the doctrine. I mean, I was going to bring up, the Google versus Oracle case on this, but that might just be ultimately be a very narrow case about APIs, which I hope they don't start going. I hope the court doesn't start going crazy in that case, but and it may just be a very narrow technical case about APIs, but it certainly has implications for, even the G-code files you mentioned before and the printers and sort of interoperability of these printers and things like that, and how far do we go? And we think 102B and originality and copyright law have tried to police those, but haven't done it effectively. I mean, I think that the problem, I'm not trying to be devil's advocate here, but we have to sort of look at the arguments that work against us, because I think we're in agreement about the non-copyrightability of the digitization of a utilitarian object. But I mean, the argument that seems to come up again and again, at least the Federal Circuit says it, is, individual utilitarian things aren't, but once you start putting them together, at some point you do hit creativity, and
at some point
the court is nervous about trying to take that away, which it probably should not be so nervous. So I mean, that's probably the only argument that I could see somebody coming up with, to say, sure, yeah, maybe the mere digitization, but this might go beyond that. Right?
Yeah, I think, you know, we've
Price problem again. So
it comes back to the development of software copyright
yeah,
law generally,
yeah,
where maybe that was a good policy move to give software copyright, some verbatim copying. But I don't know that the same policy implications play in when you're talking about digital versions of utilitarian objects.
right.
I think it's arguable. So
Yeah. We have about, I think about 5 minutes left. I have another meeting to get to. I know I don't want to take up your time. This has been a great conversation. Maybe we can continue it at some point. But do you have any, we didn't even get to the trademark section, which raises some interesting questions too. But since we only have 5 minutes, I'll give them to you. I mean, what do you think are the, at least a handful of major takeaways that you want people to get from our conversation and from your book? And
yeah,
I guess with the caveat, get the book, read it, and then these are the takeaways you should get from having
yeah.
read the book.
So the big takeaways, I think, are number one, before people advocate for policy changes or law changes, make sure they understand the technology well, because it matters. The second thing is, all things being equal, let's regulate slowly. And that goes for whether you want to strengthen the law or weaken IP law, either direction. Let's go slowly and watch what happens before we make some arguably mistakes that we made in other areas in the past in response to technology, that we rush to regulate out of fear or without fully understanding its implications, because we don't still know how fast 3D printing is going to go.
Yeah.
So that's those two things are pretty easy to say, yeah, generally speaking. Doctrinally, I think the thing I feel most confident about is the copyright thing we just spoke about. I think that it's worth very careful study and consideration that we don't grant copyright protection to these utilitarian objects. We really could slow the diffusion of utilitarian objects like prosthetic devices, etc., if we stamp every single file as automatically copyrighted. I don't know that that's the right policy in the utilitarian sphere.
Yeah.
The second thing is, I think there are protection gaps in patent law. So one thing that I was, it came about naturally, but I think I was pleased with, is the book wasn't sort of, let's do away with copyright and patent, or let's strengthen it. There were balanced statements on either side. And in the patent arena, I think it's very clear we have a patent protection gap with the file that we buy and sell, the surface touch file. That's where the economic value is. And so I think it's worth careful study. Do we need to look for ways to protect that more closely?
Right.
And then the converse is, though, we do need to look, have we changed the costs and risks of innovation enough to where actually that protection gap happens to coincide nicely with a decreased need? And so maybe, again, we end up doing nothing for a while, because even though we recognize the gap, we also recognize the lowered costs. And so perhaps, and the lower cost of imitation as well. So maybe we have some time to watch and see before we make any decisions.
That's a great way to end, and thank you for spending the hour with us. I really appreciate it, and look forward to talking again in the future. 3D Printing and Intellectual Property, Lucas Osborn, Cambridge University Press.
Okay, thanks so much, Shuba.
No problem. Thank you.